Hi, this is Peggy Clary of Clary Law Offices, one of our estate planning attorneys, and I want to thank you for tuning in to our daily video chat. Today's subject is something that is one of the most asked about and most heavily litigated questions that I encounter here in the firm, and it involves the distribution of your tangible personal property, and in non-legalese, and also as my children affectionately call it at home, your stuff. So it's items of property which you can pick up, which you can touch. So tangible is the word we use, but some examples of that might be my ring, this necklace, your automobile, your furniture, your couches, your paintings on the wall, but really anything that is tangible you can pick up and touch. And to help families, or at least a person, decide what to do with that, the first step is to really realize, what do I have of tangible personal property? So for some people, it's helpful to do a jewelry inventory to really recognize what you still own, what you already haven't gifted. Might be helpful to look around your house and determine what valuables you have. But in planning of what you need to make that list to distribute, the first step is to really understand what I have. That sounds really common sense, but for many families, a big source of argument is, well, I thought mom had this, where did it go? And so by you as the person creating a will to help you dispose of this property, it's helpful to know what you're starting from. Then secondly, Florida law has some really effective tools that are under the statute. So once you use these tools, then your wishes are honored and fulfilled. And one of the first things you can do under a will is specifically devise out where you would like certain items to go. And you can do that with a very broad statement, such as I give and devise my furniture and furnishings to my daughter. Or you can create more specific list and make sure that a piece of property that you really want to go to that child under your will can be distributed to them. Now, it's a lot sometimes in a will to create all these little lists, so Florida law also has another beneficial and easy way to dispose of tangible personal property, and that document is called a separate writing. So in a separate writing, after you've executed the will, you can create a list. And for example, I could say I give my ring to my daughter, I give my necklace to my son, my beer mug collection to my nephew, and then 5 years later, let's say I maybe just want to change my mind, or I no longer have the beer mug collection, I can just make a new list and I don't have to worry about going into the attorney's office and updating the will or creating a new will. So the most important thing to remember as you're moving forward in dealing with the distribution of your tangible personal property is to, one, understand what you have, because remember, a will only controls assets that are in your name alone. So if you and your husband own the sofa together and your husband survives you, you can't give something away that you don't own individually. And then two, think about the ways and tools you want to use to plan for the distribution of your stuff or your tangible personal property. And that might be just a general article in the will, or it might be using the separate writing, but working through how you want those assets to be distributed. A lot of people in their will planning think about larger assets, your home, your bank account, but remember, the items of tangible personal property have value too, and oftentimes serve as one of the most litigated areas. Hope this information was helpful to you. And if we here at Clary Law wish you a life of dignity, civility, and respect, if we can help you plan for your distribution of tangible personal property, or maybe you're in one of those disputes now, so you know firsthand how ugly that can be, we stand ready to help you, and thank you for your time.